She stood on her porch, watching two men in suits hammer a foreclosure notice into the wood beside her front door. 68 years old, 4 generations of her family on this land, and the bank wanted her gone in 30 days. Yes, this is that story. The bank really did seize her 1,200 acres. She really did warn them something was wrong, and they really did laugh her out of the room until the day the judge went completely silent in open court. Before we go further, comment below and tell me where in the world you're watching this from. Her name doesn't matter as much as her land did. 4 generations of her family had worked this stretch of Oklahoma soil, 1,200 acres of wheat fields and cattle pasture that her great-grandfather had claimed in a land run over a century ago. She'd buried her husband on a hill at the edge of the property 2 years earlier. She had no children living nearby, no lawyer on retainer, no idea that a routine bank refinance her husband had signed 6 years before his death would become the weapon used to take everything from her. The trouble started without warning. A letter arrived claiming a missed payment from years back, one she insisted had been paid, in full, on time. She still had the receipt, yellowed and folded in a shoebox, but the bank's records showed no such payment ever clearing. When she called to dispute it, she was passed between 4 different departments, each one telling her the same thing. The debt was valid, the foreclosure process had already begun, and there was nothing to discuss. She wasn't the type to give up easily. Driving 40 minutes into town with that shoebox receipt in hand, she sat across from a loan officer who barely looked up from his screen. She told him plainly, "Something is wrong with your paperwork. Check it again." He smiled the kind of smile people give when they've already decided you're not worth their time, and told her the bank's records were never wrong. That night, unable to sleep, she pulled every document she could find from an old filing cabinet in her husband's office. Loan papers, deeds, correspondence going back a decade. Most of it meant nothing to her. One folder, though, stopped her cold. Buried inside was a second copy of the original loan agreement, and the numbers on it didn't match the numbers the bank was now using to justify the foreclosure. Not by a little, by tens of thousands of dollars. Cross-referencing dates, signatures, and payment stamps kept her at that desk until 2 a.m., the weight of what she was reading slowly sinking in. This wasn't a mistake anyone at the bank was likely to admit to on their own. If she was right, someone had altered the terms of her loan after her husband signed it, years after. And the small-town bank betting she'd never notice was about to find out exactly how wrong they were. 3 photocopies came off the machine that night. One for herself, one for a lawyer, if she could find one who'd listen, and one just in case something happened to the other 2. She drove to 3 law offices before anyone agreed to even look at the folder. The first 2 turned her away at the front desk. Foreclosure cases against big banks weren't worth their time for a client who couldn't pay much up front. The third lawyer, a young associate barely 5 years out of law school, agreed to take 15 minutes with her out of what she later suspected was pity more than interest. 15 minutes turned into 2 hours. He compared the 2 loan documents side by side, checked the notary stamps, checked the signature dates, and went quiet in a different way than the loan officer had. Not dismissive quiet, careful quiet. He told her that if what she was holding was authentic, the bank had altered material loan terms without her husband's knowledge or consent, years after signing, and used those altered terms to manufacture a default that never should have existed. But knowing something is wrong and proving it in court are 2 very different battles. The bank had a legal team. She had a shoebox and a young lawyer willing to take a risk. Before we go further into what happened when they brought this into a courtroom, hit subscribe, because what happens next is the part most people watching this can't believe actually happened in an American courtroom. The case moved faster than either of them expected. The bank, confident in their paperwork and unaware she'd found the discrepancy, pushed for a quick foreclosure hearing, assuming, correctly, that most people in her position simply give up. Her lawyer requested something specific in return: full discovery of the bank's original loan file, the unaltered version, the one sitting in their archives before anyone touched it. Objection followed objection from the bank's legal team. Then, after a judge ordered them to comply, they seemed to stall for nearly 3 weeks. An unusual delay for a document that, if genuine, should have taken an afternoon to locate and hand over. That delay told her lawyer everything he needed to know. When the original file finally arrived, he stayed up comparing it page by page against the copy she'd found in her husband's office. The numbers on the bank's own archived original matched hers exactly, and did not match the version the bank had used to justify her foreclosure. In other words, the bank's own internal records now proved, in writing, that someone had changed the terms of her loan without authorization. She had gone from a widow being quietly pushed off her family's land to holding proof that the bank had altered a legal document years after it was signed. The hearing was 2 weeks away, and the bank's lawyers, for the first time, stopped returning her lawyers' calls. The courtroom was smaller than she expected, wood-paneled, half-empty, nothing like the dramatic scenes she'd imagined. The bank sent 2 attorneys in tailored suits, carrying briefcases stacked with paperwork meant to bury the judge in procedure before he could ask a single uncomfortable question. They opened confidently, walking through the foreclosure timeline as though it were routine, painting her as a sympathetic but ultimately liable homeowner who had simply fallen behind. Then it was her lawyer's turn. He didn't raise his voice. He didn't need to. Placing 2 documents side by side on the evidence table, the bank's own archived original loan agreement, obtained through discovery, and the altered version the bank had used to initiate foreclosure, he asked the bank's lead attorney a simple question. Can you explain why these 2 documents, both claiming to represent the same original agreement, list different principal balances and different interest terms? Silence. The attorney asked for a moment to confer with his colleague. The judge allowed it. What followed was nearly 90 seconds of hushed, visibly tense whispering at the defense table, 90 seconds that, in a courtroom, feels like an eternity. When the attorney finally responded, he didn't have an answer. He said the discrepancy would need to be reviewed internally. That single sentence changed everything. Her lawyer pointed out, calmly and clearly, that this wasn't a case of an honest clerical error being reviewed. This was documented evidence that the bank had used altered loan terms to manufacture a default and seize 1,200 acres of land from a widow who had done nothing wrong. He requested the court not only halt the foreclosure immediately, but formally refer the discrepancy for further investigation. Silent through most of the hearing, the judge set down his pen. He looked at the 2 documents for what felt like a full minute without speaking. Then, he looked directly at the bank's attorneys and asked one question, quietly, "Do you have any explanation for this discrepancy, or not?" They didn't. A different kind of silence filled the room this time, not confusion, but the kind that settles right before a ruling everyone already senses is coming. He didn't need 90 pages of case law. 2 documents told him everything. When he finally spoke again, it wasn't a delay, a continuance, or a request for more paperwork. It was a ruling. And it was not in the bank's favor. The judge halted the foreclosure immediately and voided the altered loan agreement in its entirety, ruling that the bank had no legal standing to seize the property based on falsified terms. Her 1,200 acres, the land her great-grandfather claimed, the land her husband was buried on, were hers again, fully and unconditionally, effective that afternoon. But the ruling didn't stop there. The judge ordered the bank to cover her legal fees in full, and formally referred the discrepancy in the loan documents to state banking regulators for investigation, the kind of referral that can trigger audits, fines, and in serious cases, criminal inquiry into who altered the documents and why. The 2 bank attorneys who had walked in that morning with confident briefcases walked out, having to explain, to their own employer, how a widow with a shoebox had unraveled a case they assumed was unwinnable for her. Outside the courthouse, she didn't celebrate the way people expect. She sat on a bench for nearly 20 minutes, her lawyer later said, just breathing. 2 years of grief, months of being dismissed and talked over, and 1 single night at her husband's old desk with a filing cabinet, all of it had led to this moment. Her case didn't stay quiet for long. Local news picked up the story within days, and it didn't take long for calls to start coming in. Other families in the county, and eventually the state, who had received similar foreclosure notices from the same bank, wondering if their paperwork had ever really added up either. Her case became the first thread, pulled in a pattern regulators are still investigating. What makes her story matter isn't just that she won, it's that she almost didn't. She was dismissed by a loan officer, turned away by 2 law firms, and outmatched on paper by a legal team the bank assumed would win by attrition alone. The only reason it turned out differently is because she refused to accept "the records are never wrong" as the final answer, and because she kept every piece of paper her husband ever signed. Her land is hers again. Her husband's grave sits on it, undisturbed, exactly where it always was. And somewhere in a state regulator's office, a file with her name on it just became the reason a much larger investigation is now underway. A shoebox receipt and a folder she almost didn't check saved 1,200 acres and exposed a pattern the bank never expected anyone to find. If this story moved you, subscribe for more real cases where ordinary people stood their ground against powerful institutions and won.